What's worse than losing half your retirement in divorce? Losing all of it. In the DeBenedetti case, husband earned $11 million as a Major League Baseball All-Star. But during their 16-year marriage, $3.6 million in community assets vanished without explanation. His secret brokerage accounts wife knew nothing about. His day trading disasters. His weekly cash withdrawals with no paper trail. A sandwich franchisee embezzlement scheme where he forged wife's signature and defrauded investors. When wife finally discovered the truth, forensic accountants couldn't find the missing millions. The result after a 7-day divorce trial? Breach of fiduciary duty, a $2 million equalizing judgment, and a quadro-legal strategy that could strip him of 100% of his major league retirement accounts. Find out what happened on appeal in episode 105, Major League Betrayal.
We explore what worked to protect wealth and what exactly went wrong so you get it right. And now, here's your host, Professor Kelly Lise Murray.
I'm Kelly Lise Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We don't just tell you what actually happened in court. We also show you why this matters to your professional practice and how it impacts your clients' wealth outcomes. Let's gavel in. In episode 105, Major League Betrayal, we answer the $3.6 million question. What are the divorce consequences for squandering marital millions and breach of fiduciary duty? And how does the aggrieved spouse recover financially when there's almost no cash left at the time of divorce? This is the quote of the DeBenedetti case. Husband, while being deposed before trial, said the following: "I cannot account for millions of dollars." He didn't testify at the 7-day divorce trial, but his deposition testimony was read into the record. What he's referring to is $3.6 million missing that even forensic accountants couldn't find. During this 16-year marriage, for 8 years, the husband was a Major League Baseball player. In college, he helped his university win the College World Series, and he was named the most valuable player. As a professional, he earned the Silver Sluggers Award. He helped his team reach the World Series. His career earnings were over $11 million, and after 35% in taxes, his gross net was over $7 million. But that's where that $3.6 million missing comes in. It accounts for almost 49% of his after-tax earnings. Husband retired from professional baseball in 2008, and as with many professional athletes, the professional transition to a new career was difficult. The wife, while the husband was a Major League Baseball player, earned approximately $2,000 a month, and she was the mother of 3 children from this marriage. Evidence elicited at trial demonstrated the husband's total control over finances, cash, investments, debts, everything. There was no accountability financially to the wife. No information was shared. Many accounts that the husband opened, the wife had no access to, had no knowledge of. Husband's stated excuse for total financial control over 16 years of marriage was that the wife wasn't, quote, intelligent enough, close quote. Those words have consequences. Those words have consequences in the divorce trial and on appeal. There are actually 2 appeals. They were pending almost at the same time. In this episode 105, part 1 of 2, we're focused on the finances and the resolution of wife's claim of breach of fiduciary duty. In episode 106, part 2 of 2, we'll look at a radical request for order that wife and her lawyers pursued in the trial court and on appeal. One tax and legal consequence of keeping wife in the dark was that she pursued innocent spouse relief with the Internal Revenue Service. This is really important in any marriage dissolution where there are significant tax issues and only one spouse was the controlling spouse or the managing spouse. If the other spouse has no information about the taxes, no input, and was kept in the dark, innocent spouse relief can be an important protection for spouses who were excluded from marriage finances. The money trail is critical in this case. Major League Baseball gross earnings over an 8-year career, around $11 million, with a 35% tax rate. His gross net was over $7 million. The remainder of these numbers were calculated by the wife and her financial team, including forensic experts and QDRO experts. Family expenses for about 14 years were nearly $3 million. Documented major purchases over $800,000. Basic subtraction using the data generated by the wife's legal team and her financial team. $7 million in gross net income minus nearly $3 million in family expenses for 14 years, $800,000 in documented major purchases, leaves $3.6 million unaccounted for. Because the husband's total financial control included little to no record keeping, mostly cash withdrawals, forensic accountants couldn't find where $3.6 million went. The husband testified at his deposition, "I cannot account for millions of dollars." The $800,000 in major purchases included a $450,000 loss concerning a beach house, purchases of 6 luxury vehicles, a Mercedes and 2 Land Rovers, and other expenses that the wife had documentation for. In addition, there were stock market losses, including 2.5 to 3 years of disastrous day trading by the husband. Another big issue, weekly cash withdrawals by the husband, thousands of dollars at a time. No receipts, no records, no idea in divorce of where these thousands of dollars went and what he spent it on. The day trading losses occurred between 2011 and 2013. This is a key period because it's right before the husband and his wife invest in what turned out to be a successful business opportunity. This is after he retired from Major League Baseball. The obvious red flags financially: no accountability, no documentation, thousands of dollars of cash withdrawals for years. Starting in 2013, the husband's business prospects improved. He and his wife withdrew from retirement accounts to invest in a sandwich shop franchise. They were franchisees. They started with 1 store, added 2 more stores. Ultimately, their company, IHG, acquired 6 stores, 6 sandwich shop franchises, with the help of additional investors, and some of those investors were former Major League Baseball teammates of the husband. The husband was the manager of these 6 stores from 2013 to 2016. His salary was $120,000. He and his wife owned a 56% share. The remainder was owned by the various investors. Unfortunately for everyone, this positive business transition didn't remain positive, because the $120,000 a year salary for the husband to manage the 6 shops did not cover his family's expenses. This is very common for retired professional athletes who don't make the transition in their lifestyle expenses. Keep in mind that during the 8-year Major League Baseball career, the husband has already squandered millions of dollars. This family does not have the cash reserves it needs after he retires. This business opportunity gave him a salary of $120,000, but to meet his family's expenses, including renovating the marital house after he retired from baseball, he needed double that. He needed $240,000. Without securing approval from the investors, his business partners, which included former Major League Baseball teammates of the husband, he started withdrawing additional funds from the business. He started draining the business of cash. One example is the husband, without notifying the investors and without getting their permission, doubled his salary. Instead of $120,000 a year as agreed by all of the investors, the husband doubled it to $240,000 a year. That wasn't all. Not only were the investors kept in the dark, so was the wife, to the point that the husband actually forged her signature at least 3 times in purchasing the sandwich shops. The husband, without authorization from the wife, transferred 5% of his community ownership of this business to his brother for no consideration. The mismanagement by the husband includes embezzlement, unapproved business actions, unapproved ATM withdrawals, unapproved use of business assets to personally invest in the stock market. Because the husband, without authorization, doubled his salary, he created additional tax liability for himself and his wife. One caveat is that the money the husband embezzled from the IHG sandwich shop business, he embezzled about $1 million. The wife and the family technically benefited from that money, so that money was not reaccounted for in the divorce. How was the embezzlement scheme exposed? In October of 2016, during a conference call with investors, the investor lawyer and accountant questioned the husband about the business's failure to pay $70,000 in payroll taxes. The business's profit and loss statement showed that the business had more than enough cash to make that payment, but not with the husband embezzling nearly $1 million in total over 3 years. That's how the embezzlement scheme was uncovered, and that's when the wife first learned about it, right along with the other investors. In this graph, we're showing some of the material numbers concerning the business and the husband's embezzlement scheme. Technically, from his own business, he's defrauding his business, his wife, and his investors. The embezzlement scheme is uncovered with the $70,000 unpaid payroll taxes. The husband's salary was supposed to be $120,000 a year. He, without authorization, doubled it to $240,000 a year to help meet his family's lifestyle expenses. The total embezzlement was approximately $1 million. And at the time the embezzlement scheme was uncovered, the business was valued by the investors. Again, terrible documentation, but what they could discern, it looked like the business in total was worth $2.4 million to $3 million. Husband and wife's 56% share was valued at $1.4 million. In 3 years, from 2013 to being caught in 2016, the husband had already embezzled $1 million of he and his wife's $1.4 million ownership interest. The unraveling, that October 26, 2016 disastrous conference call with investors, their lawyer, their accountant, and the wife. At that conference call, the wife testified that she learned about the embezzlement and, quote, lots of illegal things, close quote, spending weeks with the investors, their lawyers, their accountants, trying to unravel what the husband had done. The October 2016 conference call marked the first time the wife knew anything about her signatures being forged on key documents involved in obtaining the franchises, as well as the husband's embezzlement and other unauthorized activity. Not surprisingly, the embezzlement triggered tax consequences for husband and wife. The husband had withdrawn early from retirement accounts, causing additional tax liability and penalties. For one retirement account, the husband failed to pay 2015 and 2016 administrative fees, which caused early distribution, tax liability, and even more penalties. Also, the husband's embezzlement draws created 2015 and 2016 tax liability. The wife was able to secure innocent spouse relief because she was able to prove that she knew nothing about the conduct, embezzlement, and the other conduct that triggered additional tax liability, additional tax penalties. Not surprisingly, the wife helped negotiate with the investors to resolve the embezzlement situation. The wife was able to secure innocent spouse exemption from the IRS and California Franchise Tax Board, assigning all the 2015 and 2016 community tax debt and penalties to the husband. The husband and wife divested their entire ownership share in IHG as follows. First, the wife divested her half share. So 56% divided by 2 is 28%. The wife divested her 28% share to the husband in exchange for title to the marital house, including assumption of the debt on the marital house. So the wife gets the marital house. The husband now owns 56% of IHG, and presumably he's using that to negotiate with the investors because he's embezzled $1 million approximately. The 56% share that the husband now has in IHG is worth approximately $1.4 million. The husband resigns, takes responsibility for all the debts the business has incurred, all the tax liability the business has incurred. And the investors release the wife personally for liability concerning the husband's disastrous mismanagement of IHG. There's a key settlement clause that the husband tries to use against the wife later in the divorce, so let's have a look. The settlement agreement stated that the wife's transfer of her 28% share in IHG to the husband, quote, would not impact any other division or equalization of the marital estate, close quote. We have a detailed timeline of events on the YouTube version of the podcast, starting with the October 26, 2016 conference call exposing husband's embezzlement to the investors and to the wife. 5 days after that conference call, husband and wife separate. In January of 2017, the wife files for divorce. 2 qualified domestic relations orders are issued concerning the husband's Major League Baseball retirement accounts. The first quadro with the Houston Astros, that is signed December 18th, 2018. The second quadro is April 19th, 2019. In between those 2 dates, January of 2019, husband and wife are divorced. In California, this is possible in other states, but it's more common in California. You can choose to bifurcate the divorce proceedings. You can get legally divorced and reserve the financial assets for a separate trial. So that's what happens here. January 2019, the husband and wife are divorced, but their financial issues have not been resolved. 3 Major League Baseball retirement accounts are the only remaining valuable assets. There's almost no cash left. In May of 2022, there's a 7-day divorce trial to address the financial issues, which really turns out to be a trial about husband's breach of fiduciary duty. Husband claims he was ambushed by the wife and her team, that he didn't realize she was going to be litigating breach of fiduciary duty. We'll take a look at how the trial court and the appellate court addressed that issue. After the 7-day divorce trial in May of 2022, the trial judge signs the financial divorce order in December of 2022. Then in April 2023, the trial court grants the wife's lawyer's request for order and signs 4 quadros. 3 relate to Major League Baseball retirement accounts that were created while the husband and wife were married. 2 years after separation, the husband is reemployed in the Major League Baseball coaching system, and he gets a 4th retirement account. That account is separate property. Husband argues it's separate. The wife agrees that it's separate. All the courts agree that it's separate. So how in the world did that 4th account be subject to a quadro in this divorce? We're going to find out with the appellate court analysis. There are 2 appeals. The December 2022 judgment, the financial resolution of this divorce, favors the wife and disfavors the husband. Not surprisingly, the husband appealed. That appeal is resolved in 2024. That's appeal number 1. We'll focus on that in this episode 105. But there's a separate appeal. That appeal is resolved April of 2025. We'll address that in episode 106, which is part 2 of 2 in this Major League Quadro series. What was included in the December 2022 financial order by the divorce trial court? 4 key things. The first finding is that the husband failed to disclose marital financial information to the wife throughout their 16-year marriage despite repeated requests. By excluding her entirely from the finances, he became the managing spouse. That changes the burden of proof. The wife was the non-managing spouse. Second is the failure to account. As the managing spouse, the husband had the burden to account for $3.6 million in cash that was missing, that the forensic accountants could not find. This is 49% of his after-tax earnings throughout his entire Major League Baseball career. His after-tax earnings are a little over $7 million. $3.6 million is missing, unaccounted for, untraceable, because most of it was withdrawn as cash with no paper trail of where it went. In addition to the missing $3.6 million is the gross mismanagement of IHG, and the trial court concluded that this was not simply bad luck or bad decision making. The husband engaged in reckless and intentional misconduct that he squandered millions of dollars. Third, retirement fund mismanagement. The divorce court found that the husband failed to pay 2015 and 2016 administrative fees, which caused an early distribution, taxes, and penalties. There are additional taxes and penalties from embezzling from his own company, IHG. Interestingly, on appeal, husband and his lawyers argue in the briefing that the judgment against the husband had nothing to do with the actual retirement accounts. That's false. In part, his mismanagement of the retirement accounts, early withdrawals that the wife had no part of, and then this 2015 and 16 failure to pay administrative fees reduced the value of the retirement accounts themselves to the detriment of the community. Fourth, nature of the conduct as the managing spouse. Because the husband was held to be the managing spouse, he had boxed out the wife, excluded her, kept her in the dark regarding their finances for 16 years. That had legal consequences in the divorce. The court held the husband's conduct was intentional, reckless, grossly negligent as the managing spouse. The husband presented no defense to these activities, and the court concluded millions in cash has been squandered, leaving the wife's retirement assets virtually nil. That's an incredibly important quote. There is no cash in this divorce. The only asset that has any positive value are 3 Major League Baseball retirement accounts. And by the time of the divorce trial and the divorce judgment, the financial judgment, the husband is employed in the Major League Baseball system, and he has acquired a 4th Major League Baseball retirement account. That's separate, not marital. Millions in cash has been squandered. Nearly half of the husband's after-tax earnings for his entire Major League Baseball career is missing. How is that calculated? His gross earnings were about $11 million. 35% tax left the family with over $7 million. $3.6 million missing out of $7 million is 49%. 49% of his after-tax earnings are gone. There's nothing to show for it. And forensic accountants couldn't find these missing millions. So what's the deal in California with fiduciary duty obligations? It's statutory. California has lots of divorce forms and lots of divorce statutes. Both of these appellate opinions take us through many of the California divorce statutes. Here we're looking at the legal framework regarding fiduciary duties spouses in California owe each other regarding community assets. Disclosure and equal access. What does that sound like? The opposite of what happened during this 16-year marriage in California. Family Code 721B. Spouses owe each other the highest good faith and fair dealing, similar to fiduciary duties in business partnerships. Because community property, each spouse has an undivided interest in half. Family Code 1100 mandates equal management and control of community property, with a duty of full disclosure of material facts and equal access to financial records. What does this marriage sound like? The exact opposite of what is required. The wife was kept in the dark for 16 years. She didn't find out the magnitude of the husband's mismanagement of millions of dollars in cash until that October 2016 conference call regarding the sandwich shop franchise business. Courts interpreting these statutes confirm that there is an affirmative duty to disclose to your spouse without even being asked. The managing spouse cannot claim that the other spouse didn't ask. Financial secrecy, like what happened here, is a breach of fiduciary duty. Burden of proof is also important, and it helped confirm the trial court judgment in favor of the wife and against the husband on these financial issues and the $3.6 million that's missing. Number one is the requirements of a prima facie showing. The non-managing spouse, here that's the wife, showing the existence and value of community property controlled by the managing spouse and missing assets. The wife was able to document the $7 million in after-tax earnings throughout his baseball career. She documented what the family spent. After documenting $3.6 million in cash is missing, unaccounted for. The burden shifted to the husband as the managing spouse. That's number 2. Because the non-managing spouse met the prima facie burden, the burden shifts to the husband as the managing spouse to prove proper disposition of all community assets. And that's why the quote of the case matters. At his deposition, the husband testified, "I cannot account for millions of dollars." He presented no defense, which means he didn't meet his burden, which brings us to number 3, failure to account. The husband, as the managing spouse, failed to meet the burden, admitting, "I cannot account for millions of dollars," and provided no satisfactory explanations. Husband admitted millions were missing, lacked documentation, and no credible explanation. Number 4, the liability charge. After the husband failed to account, the court charged the managing spouse, husband, with full liability for the $3.6 million in missing community funds. Husband is responsible for $3.6 million missing. That's where California statutes kick in. What is the consequence of that for the non-managing spouse? We're going to take a look. The trial court award favored the wife. It's interesting because it has been referenced as a damage award, but that's really not what it is under the California statutory scheme for fiduciary duty and breach of fiduciary duty. The primary award was half of $3.6 million because $3.6 million in cash is missing. That means the wife's share of community property was artificially reduced by $1.8 million, which means the wife's judgment is for half of the missing millions. Half of $3.6 million is $1.8 million, and that is the start of the judgment in wife's favor, $1.8 million, which makes this a $5 million mistake for the husband. He squandered $3.6 million, and now he has to come up with $1.8 million to make the wife whole from his squandering. It isn't just bad luck or bad information. This was misconduct and squandering of $3.6 million. So the first part of the judgment in the wife's favor is $1.8 million. Various briefs described it as damages. It's really not damages. It is restoration of wife's share of community property. She proved he earned after taxes in Major League Baseball $7 million. $3.6 million is missing. Her share of that is $1.8. It is a restoration of what she should have had. The legal basis with the arrow on this slide is Family Code 1101G. It mandates remedies for breach of fiduciary duty. It requires awarding 50% of undisclosed or improperly disposed assets to the non-managing spouse. It is a restoration, not damages in the sense of non-marital civil contract breach. There's an important legal distinction that we will see in the appellate analysis. Breach of fiduciary duty and the consequences of that breach, that restoration, 50% of the mismanaged assets, the missing millions, here $1.8 million for the wife, is not a contract debt. In addition to providing no defense, no information about where $3.6 million in cash went, the husband evaded discovery, both requests for admission and interrogatory answers. The court held that the husband's evasive answers violated the Code of Civil Procedure, and some of his violations triggered a mandatory sanction, costs of evasion. Two numbers are important here, $100,000 and $130,000. Let's start with the $130,000. The husband's answers to written questions, interrogatories, were evasive, and he was sanctioned for those discovery violations in the amount of $130,000, basically the wife's legal fees to deal with his evasion of interrogatory questions. In addition, there's a mandatory sanction under California statute for breach of fiduciary duty. That sanction, because it's mandatory, does not get reduced with the argument from the defendant, I don't have $100,000. On appeal, husband and his lawyers argued that the $100,000 number should be reduced because he didn't have the ability to pay the $100,000. Because it's a mandatory sanction for breach of fiduciary duty, the $100,000 sanction was affirmed on appeal. The $130,000 in legal fees for evading interrogatory responses was affirmed on appeal. So if you add 1.8 million, 100,000, and 130,000, it's essentially a $2 million judgment in the wife's favor. Question: how is she ever going to recover this? There's almost no cash in this marriage dissolution. At this point, there's almost no cash. The only money left is in the husband's Major League Baseball retirement accounts. Appeal number 1. Husband challenged the $2 million judgment against him and in wife's favor. There were no facts in dispute on appeal, which meant the appellate standard of review was de novo. De novo means the appellate court steps into the shoes of the trial court. This is a question of law, so the appellate court can affirm for any reason supported by the record, even a reason different from the trial court, which is why winning at the trial court is an advantage on an appeal, because most appeals are affirmed. That de novo standard allowed the intermediate appellate court to review the law as if no other court had ever looked at this. There were 4 grounds that the husband presented. He loses all 4. Let's take a look. First, the appellate court rejected the husband's release defense. The release concerns the settlement with the investors in IHG, holding the wife not responsible for the husband's embezzlement. The release language confirmed that it would not impact the wife's share of community property or any equalization in marital property. So that release was written correctly. There's another reason why this appellate issue fails for the husband. Because of the $1 million the husband embezzled, that money was spent in part on family expenses. So the wife has no claim in the divorce that $1 million is a marital asset the husband dissipated. They actually, as a family, used that money. And the divorce trial court did not award the wife anything out of that $1 million. The $1.8 million judgment, where you add the sanctions, becomes $2.2 million. None of that number includes the $1 million the husband embezzled from IHG or the $1.4 million husband and wife's ownership interest. And the wife, in exchange for divesting her ownership interest, received the marital house and assumed that debt. The second argument that failed on appeal for the husband is insufficient evidence. The court found ample evidence of husband's misconduct over 16 years, confirming he was the managing spouse, the wife was the non-managing spouse, the 16-year pattern of secrecy, forging the wife's signatures in the franchise agreements where IHG was purchasing some of those stores, and then, of course, the embezzlement from IHG. Third is an ambush claim. The husband argued in the first appeal that he did not know at trial the wife would argue breach of fiduciary duty. This is important for lawyers to think about, being even more explicit in the legal theories. Now, the wife survives this challenge, but it really shouldn't even be a challenge. The appellate court held that the husband had plenty of notice, including 4 months before trial, based on deposition testimony. Let's not cut it that close. This is not something that should be only included in deposition testimony because it was so important. It was the critical issue that supported the $2 million judgment. Finally, the fourth argument that failed on appeal was the sanctions challenge, that the sanctions, including the $100,000 sanction, is mandatory, irrelevant that the husband had no ability to pay it. What comprised the $2 million judgment? This is important for both the wife's success in appeal number 1 and the remaining appeal regarding the QDROs, which we'll address in episode 106. $1.8 million and $230,000. The $1.8 million is 50% of the missing $3.6 million, which itself is 49% of all of husband's after-tax earnings in an 8-year Major League Baseball career. Wife's share of what's missing is 1.8, which makes this a $5 million mistake on the husband's part. Not only did he take 3.6 million and squander it, he has to come up with another 2 million to pay the wife for her share. So he's on the hook for 3.6 million plus another 2 million. The 230,000 is comprised by two numbers. $100,000 is the mandatory sanction for breach of fiduciary duty. That's a statutory sanction. And then $130,000 in legal fees for discovery sanctions, evasive answers to interrogatories. Those are written questions. The total financial impact, the direct losses to the family, 3.6 million, wife's share of that is 1.8 million, but also the opportunity cost from IHG. And this is one of the tragic aspects of this case for this entire family. Because 3.6 million was squandered when the husband first retired from Major League Baseball and apparently wasn't prepared to retire. They didn't have the cash reserves to carry them through the years when the husband tried different career shifts to help support his family. He made many disastrous efforts, including 2011 to 2013 disastrous day trading, where they're hemorrhaging even more money. He's not making money, they're hemorrhaging money. So by the time the IHG business starts in 2013, they invest in those sandwich shops personally using retirement assets. But if they had had any kind of cushion, his $120,000 a year salary would have been enough. It is tragic that the husband started the embezzlement in part just to support his family. That business was worth 2.4 million to 3 million in total. Husband and wife's interest before the embezzlement would have been 1.4 million. So that's a lost opportunity cost, both for gainful employment and an ownership interest in the 6 sandwich franchise shop business itself. Which brings us to part 2. How is the wife ever going to be paid the $2 million? This is the question that comes up in many divorces. How do I enforce a judgment? The only asset with any value left, because the wife separately has the house, the only marital assets with any value left are the husband's 3 Major League Baseball retirement accounts from the marriage. And by the time of the divorce trial and these appeals, the husband is reemployed in the Major League Baseball coaching system, and he obtains a 4th Major League Baseball retirement account. That's separate. That's it. That's where the money is. The husband has no cash. The wife has no cash. So how is the wife going to receive the restoration, 1.8 million plus 230,000 in sanctions and legal fees? How is that going to happen? That's the focus of episode 106 and the second appeal. The key legal question in episode 106 and the second appeal is this. The California Family Code 1101G, mandating reimbursement to the aggrieved spouse for breach of fiduciary duty, that is what the $1.8 million judgment is. It's a reimbursement. It's a restoration of community wealth that the husband squandered. The wife didn't squander it. She had nothing to do with it and didn't know about it. So how is she made whole? It could be described as damages, but that's inaccurate. It is restoration, in a sense, an equalization of payment, but it's truly restoration under a mandatory California statute. Our takeaways are financial, familial, and emotional. The psychology of this, starting with the husband's successful Major League Baseball career. He actually was a college baseball star. He and his collegiate team won the College World Series, and the husband was the MVP, winning the College World Series. He's drafted into Major League Baseball. He helps the Houston Astros reach the World Series. He wins the Silver Slugger Award. For all of that baseball success, what happens when you retire when you didn't expect to retire? It is not uncommon, and it is unfortunately common for professional athletes to not have enough money after their playing career is over to sustain the business transition from professional athletics with high compensation to whatever additional pursuits they choose as no longer an athlete. And that is somewhat what happened here. If you look at the timeline, the husband really struggles Especially, he retires in 2008, 2009. 2011 to 2013 is the disastrous day trading. So they're hemorrhaging even more money. It wasn't until 2013 that the IHG sandwich franchise business is created. And at that point, they don't have the reserves for his salary to pay the family expenses. Then the forensics. Forensic accountants could not find the missing millions because most of it was cash withdrawals, and the husband failed to disclose where any of it went. There was no paper trail to follow. There were not assets to find. This is not hidden assets. The money is just gone. The wife has deposition testimony where she concludes, I don't know what he spent it on, and then she lists some possibly illegal things. Well, we don't know if he did any of those things, one or all of them, but the money was spent, it was squandered, and there is no asset to attach to bring that value back to the wife. The legal and strategic analysis is this breach of fiduciary duty. Breach of fiduciary duty is an important issue in California. Every other state, you're going to need a statutory scheme like California. California is a community property state. Equitable distribution states don't work like this. In addition, California has many family law statutes, and appeal number 1 in this case and appeal number 2 go through many of those California statutes. But the takeaways are still important in terms of the evidence needed to show, for example, innocent spouse relief with the IRS. Requesting financial access from your spouse and being denied that access, evidence of that is important for breach of fiduciary duty in California. It would be equally important in any other community property state and in equitable distribution states. The ultimate irony in this case is the drastic contrast between the husband's significant success in Major League Baseball and disastrous choices in managing his family's finances, both during his baseball career and then after. We include in the show notes the case citations, and on our website, withdrawals.com, we have links to the actual public version of the appellate decisions themselves. But the story doesn't end here. In episode 106, part 2 of 2, Major League QDRO, we look at the wife and her lawyer's radical legal theory to fund the $2 million judgment, despite the fact that there's no cash left in this marriage, and the only valuable assets left are the 3 Major League Baseball retirement accounts, which at this point have already been divided 50-50 as community property. Thank you for joining us. Stay tuned for a preview of our next episode. How do you lose 100% of your retirement assets in divorce, even after community property has already been divided? In the Benedetti case, wife secured a $2 million judgment for husband's breach of fiduciary duty after he squandered $3.6 million in cash that even forensic accountants couldn't find. Next, wife's lawyers filed a radical request for order in the trial court and on appeal, seeking 100% of husband's 4 Major League Baseball retirement accounts, not as division of marital property or modification, but as a state statutory reimbursement of squandered marital millions, creating a marital property right enforceable through QDRO. In episode 106, Major League QDRO, part 2 of 2, we explore the legal strategy and appellate court analysis potentially transferring a QDRO grand slam. That is 100% of 4 Major League Baseball retirement accounts to one spouse, even after the original QDROs split them 50-50, and even though one was separate property. Don't miss it.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.